Greetings, everybody, and welcome to today's webinar, OSHA in 2019, What Employers Need to Know, presented by Quarles and Brady. My name is Kerry Mohan. I'm an attorney in Quarles' Labor and Employment Practice Group. My practice focuses on counseling employers on compliance in a wide variety of federal and state employment and labor issues, including occupational safety and health, corporate transactions, employee discipline, terminations and reductions in force, performance counseling, employment litigation, leaves of absences and accommodations, collective bargaining agreements, union organizing, executive compensation, employee severance, and most more. I'm co-presenting today's webinar with Fred Gantz, a fellow partner in the firm's Labor and Employment Group. Throughout his career, Fred has represented companies in defense of discrimination complaints, employer counseling, traditional labor, including collective bargaining and unfair labor practice charges, and representation on OSHA matters and citations. He has represented employers across the country in courts and 4 state and federal agencies, including the National Labor Relations Board and the Occupational Safety and Health Administration. We are very pleased to have you attend this presentation today. Before we begin the presentation, we have a few housekeeping items to go over. We will be applying for 1.0 hours of CLE credit. If you are an attorney and would like to receive the CLE credit for attending today's program, please fill out the CLE form located at the back of the materials found in the handouts panel of the webinar dashboard. Please complete the form and return it to the contacts listed at the bottom of the document. There is also an HR certificate of attendance form in the dashboard materials for human resource professionals to use in self-reporting. Please be aware that we have muted all phone lines for those dialing in and for participants listening to audio via computer, so you will not be able to speak. We are in listen-only mode. We would like you to be aware that this presentation is being recorded. An electronic survey will be emailed to you after the program. And finally, if any webinar participants have a question, please type your question in the chat box located in the upper right corner of the webinar dashboard and press submit. Every effort will be made to answer questions near the end of our time together today.
Well, good morning. And as Terry told you, my name is Fred Gantz. I'm going to cover the first part of today's program. And I'll first go over an overview of what we plan to accomplish. We're going to discuss first some OSHA basics that we think everyone should know, whether you're a safety manager or you're responsible for recording various incidents that occur in the workplace. We'll talk about injury reporting requirements, managing an OSHA inspection, employee interviews, how to address and defend OSHA citations, administrative changes that have occurred during the Trump administration, potential criminal liability, and developments in 2019. So let's take a look at this statute, which was enacted in 1970. The Occupational Safety and Health Act is referred to as the OSHA Act, and it was created to ensure a safe working environment for all employees. One of the ironies of a lot of our laws that benefit employees is a lot of times they were enacted during Republican administrations. So in this particular instance, this is a law that came into effect during the Nixon administration. When it was first enacted, many employers were upset. Its 50th birthday will be next year, and it's not going away. The Occupational Safety and Health Administration, known as OSHA, is the administrative arm of the OSHA Act. Now, OSHA has various tasks. One of them is to develop and issue new safety and health regulations. And these are also often referred to as standards. So if you hear the term standards in the OSHA sphere, it means the same thing as regulations. Now, another thing that OSHA does is it provides guidance and interpretations for these regulations. And as is often true with a number of federal agencies, in particular the National Labor Relations Board, the interpretations for these regulations sometimes change during administrations. And we'll talk with you about some changes that have occurred quite recently. In addition, OSHA conducts workplace investigations, and many of you may have experienced that at some point. And finally, OSHA issues citations for alleged violations of its health and safety regulations. Now, OSHA is comprised of federal OSHA and state plans. There are 21 state plans that are applicable to the private sector. For example, among Quarles and Brady's offices, we have state plans in Arizona, Indiana, Minnesota, and California. Cal OSHA is the most aggressive of the state plans, and our OSHA practice is national. We have represented clients on matters in Wisconsin, Arkansas, Arizona, Illinois, Tennessee, and Texas, to just name a few of the states in which we have represented employers. Now, OSHA issues regulations in certain areas. General industry is the one that is very prominent. OSHA is also very active in the construction industry and in other areas shown on the slide, and it has separate regulations for record keeping. Now, in addition to the regulations, OSHA has a general duty clause, which is section 5A1 of the OSHA Act, that requires employers to provide employees a place of employment free from recognized hazards that are causing or are likely to cause death or serious physical harm to employees. Now, whenever OSHA cites an employer under the general duty clause, it must be designated as a serious classification. And for that reason, we often propose changing a violation to a more specific standard, setting the stage for a possible settlement using the other than serious classification. Now, in the event OSHA finds violations of its regulations during an inspection, it can issue the following citations and maximum penalties. It can issue a citation for what's called an other than serious violation or a serious violation. And as you'll see, these maximum penalties have risen quickly. If you faced an OSHA citation in 2018, the maximum penalty was under $13,000, and now for an other than serious or serious violation, as you'll see on the slide, it's over $13,000. OSHA also issues sometimes repeat and willful citations, and these carry with them a much higher penalty. The maximum penalties are now over $132,000, which is a $3,000 increase from last year. So these numbers adjust every year, and these are the latest maximum penalties. There are situations where OSHA might issue a penalty, particularly in the serious and other than serious category, in which the dollar amount may be less than the maximum we've shown here on this slide. Now, on the next slide, we've shown you the most cited standards for OSHA's last fiscal year. And as you'll see, one of the major ones that employers need to be concerned with, whether in construction or general industry, is fall protection. There's a number of related violations that we think kind of play out as very similar to fall protection, such as, if you take a look at the slide, for scaffolds, ladders, and fall protection and training. So sometimes it's very important to remember OSHA wants to know that you are training employees on a regular basis, at least annually, Very often, if you're on a construction site, that there's training that's occurring either at the beginning of each day or certainly the beginning of each week. In addition, some other areas that we see very often involve hazard communication, lockout, tagout, respiratory protection, powered industrial trucks or forklifts, machine guarding, and personal protective equipment. Now, another thing that we encounter quite a lot is that many employers are not aware of OSHA's reporting requirements. So, for example, in the very unfortunate situation where a fatality occurs, and I can tell you that unfortunately there's a number of situations we've had in 2018 where employers have contacted us to report a fatality. And here OSHA requires that a fatality must be reported within 8 hours of the employer becoming aware of the fatality. So one of the things that happens very sadly is sometimes these incidents will occur in the evening or on a third shift overnight. There is an obligation to report these very promptly, and we'll talk about how you handle those situations on the next slide. In addition, if one of your employees has an inpatient hospitalization, amputation, or eye loss, that must be reported within 24 hours of your becoming aware. And there are some limitations on this. This only must be reported if the event occurs within 24 hours of the work-related incident. And another thing that a lot of times employers don't realize, if there is an inpatient hospitalization that only involves observation or diagnostic testing, that need not be reported. And so, for example, you could have a situation where an employee may have incurred burns on an arm and is actually kept overnight, but it was really done only for observation. That's a situation that need not be reported. And one of the things that we found over the years is that it's important you know when to and when not to report an injury, because if you're reporting too frequently, that can influence OSHA potentially wanting to come to your workplace if they're seeing a lot of injuries reported that perhaps didn't need to be reported. Another question that comes up a good amount of time is there are many situations where we're contacted by an employer and one of these deadlines has passed. For example, a fatality was not reported within 8 hours because it occurred either it occurred at a time when the OSHA office might be closed, either in the evening or early morning hours. And what we do there is it's one of these situations that it's better to be late than never. You just you make your contact as soon as possible, and that's better than not reporting. How do you make the report? What you do is you call the nearest OSHA area office, and this is assuming that the injury occurred during the workday. So, if it occurs between 8:30 and 4:30, you call the nearest OSHA office. If the OSHA is closed, OSHA has a 24-hour hotline that you can call, and both the numbers for these can be found on OSHA's website. When you call, you supply the name of your business, the affected employee or employees, the location, time, and a brief description of the incident, along with the contact person and phone number. I'm going to stop here, and Carrie's going to pick up discussing OSHA inspections.
Thank you, Fred. So one of the more frequent questions we get is, what has the OSHA been like under the Trump administration? I can tell you that OSHA just recently received its new head of the OSHA of the administration. And so up until that point, many of the lifelong employees, servants within OSHA said it's business as usual. And that's generally what we've seen in regards to inspection, and that they largely remain the same. Inspections are almost always compliance officer driven. And so some compliance officers are more aggressive than others. They may be more willing to push the boundaries as to the scope of the inspection, number of employee interviews, how aggressive they're going to be. And we see the same thing here. Now, importantly, what we're seeing too is that with administrative agencies' budgets being cut or staying stagnant, generally speaking, the number of inspectors, compliance officers for OSHA has decreased to its lowest point ever. As a result, OSHA has tended to change the focus of its inspections away from some of the more complicated cases, such as ergonomics, workplace violence in some instances, to more standard cases, such as machine guarding, lockout, tagout, excavation, fall protection, things that are clear based on the regulations as opposed to having a lot more discretion or performance-related type of inspection. But at the same time, though, because of the reporting requirements, OSHA is also more likely to conduct an investigation following a catastrophic event or a fatality. So, for instance, process safety management. Those are complicated inspections, but if you have an explosion with employee injuries, particularly numerous injuries, it's more likely that OSHA will be on site to conduct that inspection. So, managing an OSHA inspection, setting the scene, we get a call from a frantic GM saying that OSHA just showed up, showed her badge, and is demanding to immediately inspect the entire facility, take video, and interview all employees. What do you do? So, when does an OSHA inspection occur? Now, there's various instances when an OSHA inspection can occur. One is when there's imminent danger or plain sight. Imminent danger means that the circumstances are such that an inspection needs to occur immediately, and this typically occurs whenever, in relation to fall protection, excavation, and trenching, and often occurs when an OSHA inspector is driving to and from the office. Sometimes their task is just going to work sites. They'll go to see where all construction permits are and visit those sites. And for instance, for a while, there was an emphasis program where anytime an OSHA inspector saw an excavation, whether they were on duty, off duty, they were to stop and see it. And so that's a type of situation where you may get an inspection. Following a catastrophic event or reportable injury, as we discussed, and employee complaints. These are more common, and that employees are permitted under the OSHA Act to file safety and health complaints. Oftentimes, OSHA will do what is called a phone and fax, where they'll send a letter to the employer saying, we received this complaint, please provide us your written response within X days. It is important that the company respond to that request in some manner. The reason being is there have been several instances where an employer either got lost in the mail, the employer lost track of it, and there was no response provided. As a result, OSHA then conducted an on-site inspection when, if a written response had been provided, no inspection would have occurred. Referral programs, this is, say a report has been filed with EPA or with a state workers' comp organization, there may be a referral to OSHA saying you should be aware of this in case you want to conduct an inspection. Programmatic or targeted. OSHA has national emphasis programs, and each region has its own regional emphasis programs, where if you're an industry within a specific, if you're an employer in a specific industry, for instance, some regions have a program related to poultry or combustible dust, and they will identify all employers within that industry and select specific individuals or specific employers to inspect. And then follow up. Say you have an inspection and you receive citations, but you enter into a settlement agreement with OSHA with specific abatement obligations. OSHA will sometimes do follow-up inspections to ensure that you're properly abated. Now, the type of inspection is key because it sets the inspection scope, and it shows how far and broad a OSHA inspection can be. Are they permitted to be a wall-to-wall inspection covering the entire facility? Are they limited to a very specific machine? Are they limited to testing on specific chemicals or combustible dust? It's all important. And so, can you refuse OSHA access to a website? You can initially, but then OSHA has the ability to obtain a warrant to issue the worksite. Generally, we recommend that employers cooperate with OSHA and not demand that they obtain a subpoena or a warrant. But under certain circumstances, it is appropriate, and we have made recommendations regarding it. Now, also, can you refuse to provide OSHA documents? Generally speaking, we recommend that OSHA or that employers cooperate, but at the same time, though, we will push back the specific document or requests that we believe are overly broad or vague. And but the concern there is that OSHA can obtain subpoenas, and the use of subpoenas has become more aggressive in recent years because OSHA has a 6-month statute of limitations to issue citations. And so if there's delay in obtaining documents from an employer, they're more willing to issue a subpoena to ensure they get those within a timely manner. So how to control an OSHA inspection? The best piece of advice we have to any of our clients related to an inspection is that we should know and maintain and control the flow of information from the company to the inspector at virtually all times. So first thing is to obtain a copy of the complaint so that we know what the scope of the inspection is. Again, is it limited to a specific machinery? Piece of machinery, is it limited to a specific issue? Have a point person. This point person is going to be the main point of contact between the inspector and all other employees. So all document requests will go through this point person, in and out. All requests for information, all interview requests will go through this point person in and out. Control where the investigator goes. Now, that's not to say we block them from where they're going, but it does say we control the access point. So, for instance, if the piece of machinery that's at issue is in the back corner of the facility, as opposed to walk straight through the facility and let the inspector have a chance to view any unseen number of potential issues, take the inspector outside and go to the nearest door to where the piece of machinery is. Limit videos and prohibit audio recording. Employers are not required to be audio recorded, and oftentimes OSHA cannot take video without audio recording. Shadow the inspector, so you know where the inspector is at all times. You have eyes on him or her, and you take the same photos as the inspector. So if an inspector is taking a photo of a piece of equipment, you have that same exact photo. If the inspector is asking questions about a specific issue, you take notes about that. And then also push back on unreasonable requests. We understand that employers, this is can be an uncomfortable thing to do, but we often, if a request is overly broad, if it's irrelevant, we will push back on it and ask them to clarify what the relevancy is. And 75% of the time, OSHA will back off that request. Employee interviews. These are perhaps the most important part of any OSHA inspection, because this is where OSHA gets quote-unquote admissions from employers. OSHA has the right to interview employees and management. And again, they can obtain an administrative subpoena if we refuse to provide employees. Employee interviews. So these are non-management, generally speaking, hourly employees. OSHA will take the position that they should be interviewed one-on-one. Employees technically have a choice as to who they want as their representative. It can be a manager, it can be a supervisor, it can be the safety director, can be the employer's attorney. It's technically the employee's choice, but 90% of the time, plus, OSHA, the compliance officer, will push back on that and will reject management from being present during that interview. Management interviews. The company has the absolute right to be present during those interviews, because anything that is said during those interviews will be deemed an admission by OSHA. So the company's legal counsel can be present. Now, what becomes an issue is who is deemed to be a manager or supervisor. This is a statutory issue under OSHA, and it goes to who has the authority to direct issues related to safety and health. OSHA, within the past decade, has issued some decisions and issued citations on the basis that a one-person crew was its own supervisor, or a two-person crew of hourly employees with truly no supervisory responsibilities one of them was a supervisor over the other just because he or she may have had more experience. So it's important when we get into these issues, we make very clear in writing to OSHA that one, that this is not deemed a manager or supervisor, and two, if they deem it to be a manager or supervisor at any time during the interview, they're to immediately stop the interview and permit company representatives to be present. Other key issues here are employees and management are not required to be reported. It's voluntary, but they are not required to be reported by OSHA, and they also are not required to sign any statements by OSHA. Now, OSHA will oftentimes say they're not leaving without a signed statement. We recommend, particularly for management employees, they do not sign any statements. Now, under the Trump administration, there have been a few rollbacks. Some of them were earlier on in his administration, some have been more recent. One of them is related to the record-keeping statute of limitations. In 2012, for a long time, OSHA took the position that they could issue citations related to record-keeping, so OSHA 300 logs, 300A logs, anytime during the 5-year retention period. In 2012, that interpretation was rejected, and so OSHA has a 6-month statute of limitations for record-keeping issues compared to just like any other citation. In December of 2016, so towards the end of the Obama administration, they tried to issue a new final rule to clarify, to make it so that the statute of limitations would be 5 years. Shortly after Trump administration became in power, that rule was rescinded. So what that means is that the 6-month statute of limitations remains in effect. Another issue was in 2013, OSHA issued a standard interpretation saying that employees, even those that are not subject to a collective bargaining agreement or unionized, could designate any person they want to be a walk-around representative during an OSHA inspection. What this means is, say you have a union organizing campaign at your facility, they could identify the union agent as the walk-around representative. This was challenged, and the federal court sided with the challengers, finding that this was an improper attempt to create a rule without proper rulemaking procedures. And then in 2017, OSHA formally withdrew the standard interpretation. So what that means is non-unionized facilities have much more protection and authority to limit who is a walk-around representative during an OSHA inspection.
I'm going to take over at this point, and we'll talk about drug testing and incentive programs. So on this particular slide, you notice that we've talked about OSHA issuing regulations on May 12, 2016. So these were regulations that were issued during the Obama administration. And they prohibited employees from retaliating against employees for reporting work-related injuries or illnesses. Now, in the final rule, preamble and interpretive documents, OSHA discussed safety incentive programs and post-incident drug testing policies and indicated that they could violate these regulations. So take a look at post-incident drug testing. It was not prohibited per se, but it was prohibited when drug use could not have contributed to the injury or illness if the test is used in a retaliatory way. So you have to be careful that if there was simply a work-related incident or work-related injury, that if you had a policy that said we're going to test everybody who had any relationship to this injury, OSHA could become concerned about that, because they'd say, well, you have to first make a determination if there was any reason to believe that drug use could have contributed to the injury or illness. A typical situation would be if it was a forklift driver who was in an accident, it was okay to test that driver. But if somebody just happened to be hit by the forklift who was kind of like an innocent bystander, then OSHA had the view that that person shouldn't be tested. And similarly, with respect to incentive programs, If you had a situation that there was a recordable injury and therefore you were not going to provide a bonus to the employees for that situation, OSHA thought that could deter reporting of the injury. So during the Obama administration, these were areas where you needed to be much more careful. Now on this next slide, what happened on October 11, 2018, which of course is during the Trump administration, OSHA issued a clarification of its position on safety incentive programs and post-incident drug testing. And essentially, OSHA clarified that either of these situations are lawful so long as the employer does not take an action for penalizing an employee for reporting a work-related injury or illness. And so basically for drug testing, most instances of workplace drug testing are permissible, including post-incident testing, and the employer should test all employees whose conduct could have contributed to the incident. The timing of the impairment should be considered. So essentially, employers have been given more leeway here. You still have to make a reasonable judgment as to who should be tested, but in both the areas of safety incentive programs and post-incident drug testing, there is more leeway. Now, with respect to incentive programs, OSHA stated that a rate-based system that rewards employees with a prize or a bonus at the end of an injury-free month, or evaluates managers based on their work unit's lack of injuries is permissible, so long as this is done in a manner that does not discourage reporting. And what they came along and said is the employer has to implement adequate precautions to ensure that employees feel free to report an injury or illness. Well, what are adequate precautions? An employer said, basically what OSHA has stated is that you can avoid inadvertent deterrent effects of a rate-based program by taking certain actions. You can have an incentive program that rewards employees for identifying unsafe conditions. You have to have a training program that reinforces employees' reporting rights and responsibilities and emphasizes the employee's non-retaliation policy. And you should have a mechanism for accurately evaluating employees' willingness to report injuries and illnesses. So basically what we see here is the presumption has switched in favor of incentive programs, but you still have to make reasonable judgments. Now, with respect to electronic record keeping, during the Obama administration in May of 2016, OSHA issued a final ruling that stated that establishments with 250 or more employees should electronically submit their OSHA 300, 301, and 300A injury and illness logs. And then OSHA also stated that other establishments in high-risk industries should electronically submit their OSHA 300A injury and illness logs. This was referred to as the electronic record-keeping rule. Now, what OSHA wanted to do is it wanted to put all this data online, including information on the OSHA 300 and 301 logs about the employees and their names and particular injuries. And this was going to be a tactic of basically shaming employers into compliance. OSHA was going to use this data to target workplaces for inspection and enforcement. Now, during the Trump administration, and this occurred quite recently on January 25, 2019, OSHA published a new final rule, and it removed the requirement that establishments with 250 or more employees electronically submit their OSHA 300 and 301 forms to OSHA. Instead, these establishments, along with those in high-risk industries, now need only electronically submit the OSHA 308 form, which is a summary and doesn't name the employees. These must be submitted by March 2 of every year, and that includes 2019. So if this applies to you, you should have submitted your OSHA 308 form. And you might say, well, gee, what if we didn't realize that or didn't do it? Well, just as we've discussed before, better to be late than never. And one of the things to also keep in mind is this requirement of submitting the OSHA 308 form often does not apply because an establishment may consist of less than 250 employees or is not a high-risk industry. So, a lot of times you might have a much smaller number of employees at a particular location. And again, if you're not a high-risk industry, you may not have to you may not be required to submit the OSHA 308 form. Now, there's still a question of whether this final rule will be upheld. It's being challenged. And here we're seeing a different kind of challenge. In January of this year, a coalition of public and interest and labor groups filed a lawsuit challenging OSHA's decision to remove the requirement that establishments with 250 or more employees annually submit OSHA 300 and 301 logs. And similarly, in March of this year, 6 states filed a lawsuit claiming that OSHA had made an illegal and unjustified attempt to roll back its requirements for the public reporting of workplace injuries and illness. So we have a situation where certain public interest groups and states that sometimes have been regarded as very concerned about employees they actually want this information reported. So we'll see what happens next. It's pending before the courts. For now, there is the requirement to submit the OSHA 308 form, as I described, for certain employers. Now, we want to set a scene for you here in terms of something that can happen in your workplace. So 5 months ago, a company reports an incident to OSHA. OSHA conducted an investigation. It appeared to be pretty painless. The compliance officer was a nice guy, was easy to get along with. Then the company receives the notice that it's receiving 5 citations, including 2 citations, and a penalty of $200,000. Now, is this particular situation one that occurs frequently? No, not most of the time. Most of the time, when you go to a closing conference with an OSHA officer, they give you some indication of where they're at. If citations later issue, they're typically going to be consistent with what that closing conference was when OSHA was visiting. But we have had this situation occur. So what do you do when the citation comes in? Well, this slide addresses a number of situations. One of the things I want to point out, OSHA, as Kerry referred to earlier, has a 6-month statute of limitations to issue the citation. And OSHA may have visited your workplace, and I will tell you it's very common that about 2 weeks before that deadline expires, that's when you receive the citation. So you literally can count from the last time they did their inspection to see if they're going to issue a citation. If they indicated they would, they usually do. Now then, once this is received, one of the things you want to do is you want to look at, you have 15 working days to request an OSHA, to request what's called an informal conference with OSHA. And that is a very important thing to do because OSHA sometimes on a citation will provide a proposed settlement. And if you go to the informal conference, you're almost always going to be able to do better than what their proposed settlement was. And one of the things that you want to do when you set the time for the informal conference is also get a notice of contest date. What is my deadline? Sometimes there are holidays in here, and you're not sure how OSHA is counting a certain holiday. So you want to, when you're scheduling the informal conference, find out what the notice of contest date is. And if you go to the informal conference and you reach a settlement, you definitely want to, as part of that settlement, get a non-admission clause. OSHA won't offer you a non-admission clause unless you request it. You need to keep in mind that if you don't contest within 15 working days, you're going to waive all defenses. So you want to get your notice of contest ready. And sometimes employers have requested that we prepare the notice of contest, either bring it, if we're representing them at the informal conference, bring it with us, or prepare it for their signature. It's a pretty simple letter. You're basically going to contest all citations and items, abatement deadlines, and penalties. I want to point out, we've talked about these state plans. The notice of contest deadlines may be different under the state plan. So you want to be checking that out to make sure, again, you're not missing an opportunity to submit a notice of contest. So while we suggest you hold them, we do want you to ultimately submit them. I'm going to stop here, and Kerry's going to talk about contesting and litigating OSHA citations.
Sure. So what happens if we go to the informal conference and are unable to reach a settlement with OSHA? Well, as Fred was just mentioning, you file a notice of contest. And there's various reasons why it's important for an employer to contest an OSHA citation. One is the classification. Some employers take a position that we just cannot accept a willful citation under any circumstances, and we're willing to fight it tooth and nail. Other times it's the dollars. It makes sense to, if you have hundreds of thousands of dollars in penalties, which is becoming more and more common under OSHA with these increased penalties, it makes sense to challenge them because you know that litigating can result in a more favorable settlement. Abatement. This is sometimes not fully considered, but should be considered in every single citation. And if you have a citation, OSHA will require that abatement occur to abate any of the alleged safety or health hazards. Sometimes abatement is easy. Other times it is very complicated, can cost significant dollars. For instance, if your machine guarding or lockout tagout systems are not appropriate, OSHA may say you have to retrograde all of your machinery. That can cost millions of dollars, depending on the size of the facility. So whether abatement is even achievable, and then two, what's the timing of abatement? Sometimes OSHA will issue a proposed abatement date that's a short time period. So by contesting the citations, abatement dates are stayed, and you're giving yourself additional time to abate without running the risk of a failure to abate citation which has daily penalties. Competitive disadvantage. Say OSHA is taking a position that is going to make it more complicated, more costly, less efficient for your operations. Sometimes employers will say, well, I'm willing to take this to trial in case, and I'm willing to lose, because if I lose, I know all of my competitors will be subject to the same requirements, and I'm not the only one in the industry subject to these. Government contracts and subcontracts. Government agencies do look at OSHA citations, particularly willful, repeat, and serious citations, in issuing whether they're going to grant a contract or permit a contractor to subcontract to a subcontractor. So it's something where a $7,000 penalty or a citation could result in $10 million, $50 million, $100 million in government contracts in the future. Insurance coverage, the more citations you have, particularly the higher in classification, the more likely your insurance coverage is going to be increased. Perhaps you may not get that bond for that big construction project you're wanting, or it may be the expense of it makes the project not feasible. And then reputation. OSHA does issue press releases, and sometimes it makes sense to challenge the citations just to build that goodwill up in the community. So litigating an OSHA citation it proceeds before the OSHA Review Commission, OSHREC, which is the independent administrative agency. And state plans often have similar agencies like this. Not quite the same, but they're similar in that you're proceeding before an administrative law judge usually. For federally, the solicitor's office represents OSHA, so it's government attorneys. And the federal rules of evidence, the civil procedure generally apply. So just as if you were in federal court. Now, one area we like to identify is experts. In many of these cases, particularly the ones that go to trial, experts are becoming increasingly more important. OSHA will bring in experts to support its position, and the company should consider whether to bring in an expert to rebut OSHA's position and support its defenses. As Fred said, many of these lawsuits or these citations result in settlement. Very few actually go to trial. It's important to have a non-admission clause in the agreement when you have that settlement. And then two, oftentimes during an informal conference, OSHA will say, the offer's off the table if you contest. Based on our experience, that is, I do not want to say never, but incredibly rare, just because once you get the attorneys, after you contest the citation, they're, in our experience, have always been willing to go back to what was the best offer that OSHA gave you during the informal conference. As I said before, ultimately this would result in it's called a bench trial before an ALJ. There is no jury here. The typical time frame for a hearing is usually 1 to 3 days, but sometimes they can be longer. They can be weeks, depending on the complexity and size of the case. Then after the hearing, each party will submit post-hearing briefs. Once the ALJ issues its decision, which can be anywhere from 6 to 12 months, each party can then appeal to the OSHA Review Commission, which is a 3-member commission. That will either take anywhere from 3 to 18 months for the commission to actually issue an opinion, which you can then appeal to either your home circuit court of appeals. For us, it would be the 7th Circuit here in Wisconsin, or the DC Circuit. There are, under certain circumstances, more streamlined litigation options for parties when they're dealing with smaller citations with lower penalties. Usually that is more streamlined in that there's less discovery, there's usually no post-hearing briefs. So that is an option for certain citations to be able to have a quicker, more cost-effective approach. But many times, employers are going to want to engage in discovery to contest OSHA citations. What are some OSHA litigation issues? And these we're just talking about trends that have developed over recent years. And these trends have generally continued through the Trump administration just because of historical litigation that had not been finished over time. So under Obama, OSHA was very aggressive in attempting to create legal requirements through case law because they understood how difficult it is to issue new regulations or standards. Particularly seen in heat illness, workplace violence, ergonomics, and permissible exposure levels, which are exposure levels to chemicals where historically OSHA's PELs are out of date. And so they would try to use the general duty clause to require more stringent requirements. Because OSHA was so aggressive, it forced employers, oftentimes it forced employers to settle, but oftentimes employers had no choice but to contest. For instance, Aldridge Electric, which is a case that we successfully defended, was a heat illness case where the abatement obligations proposed by OSHA would have made the company unable to be profitable. For instance, OSHA's expert testified that anytime the temperature was above 80 degrees, perhaps even lower, and you had a new employee, or an employee took a 3-day weekend and was off work for 3 or more days, the first day the employee was back, the most they could work in any hour was 12 minutes. And then the second day, they can increase to 24 minutes, then 36 minutes, then 48 minutes, then finally, on the 5th day, a whole hour. Clearly, that was not acceptable abatement. The company contested it and won. And then recently, there's our OSHA Review Commission decision based largely on the Aldridge Electric decision, finding that OSHA overstepped its boundaries in heat illness. Repeat classification, OSHA has, over the years, been more aggressive in issuing repeat classifications, primarily based on the theory that if you were cited for a standard in the past, you can be cited and you get that same standard, that's enough for a repeat. A recent decision said that no, you need to show more. You need to show a substantial similarity of the alleged hazards, the statement requirements, so it provides employers much more protection now. And then finally, you have with the MARCH Act poultry, it limiting OSHA's ability to expand inspections beyond the complaint, the initial reasons for the inspection. And so it just provides companies, if an inspector is trying to do a wall-to-wall inspection, the ability, another tool to challenge that. At the same time, though, because OSHA was aggressive, they have won some cases. One with the multi-employer worksite doctrine, saying that a controlling or a host employer can be cited for violations involving another employer's employees. This has been a recognized doctrine throughout the country, except for the Fifth Circuit, and it just shows it's finally guaranteed to be nationwide. Repeat citation, so you win some, you lose some. Previously, OSHA had a 3-year look-back period. Under Obama, they moved it to 5 years, and then as a result, this decision said OSHA can look back as far as they want. And then finally, with workplace violence, there was one recent OSHA Review Commission decision that upheld a workplace violence general duty class citation against an employer in the healthcare industry. So it shows the viability of workplace violence citations moving forward. One area that we would just like to touch upon is the increasing use of criminal penalties under the Obama administration, but in particularly at the state level. Under the OSHA Act, criminal penalties can be imposed against employers for a fatality that was caused by a local violation, which can result in imprisonment up to 6 months and penalties in the hundreds of thousands of dollars. There are also potential criminal penalties for giving advance notice of an inspection or providing false information or documents during an inspection. Now, historically, OSHA did not really prosecute these, except for the most egregious of cases, because they're misdemeanors and the Department of Justice wanted to pursue felony charges. As a result, the Department of Justice has been more focused on, instead of the misdemeanors, to go for the perjury, the obstruction of justice, the providing false statements. That's been their focus. But that's on a federal level. On a state level, more and more local prosecutors are issuing charges related to manslaughter, reckless homicide, perjury as well, concealing the record, and they've had some success in recent years. And here are a number of recent examples identifying instances where criminal penalties have been brought, and sometimes successfully brought, against employers. And so what this means is, one, never lie during an OSHA inspection. If you don't have documents, do not try to backdate the documents. If you don't know if you don't know facts about the situation, do not try to create use rose-colored glasses to make it more appealing. Be honest. That's really the key thing there too. And then two is, don't ignore obvious hazards. If you have a hazard in the workplace, fix it.
I'm going to take you through a few developments that have occurred for 2019, and then we want to get to questions. So one area that Kerry has talked about several times has to do with trenching and excavation hazards, and OSHA is very big here on wanting employers to have cave-in protection. Fall protection has been identified as another area. We showed you how prominent that was in the last fiscal year. And finally, workplace violence is another area that OSHA has identified. They have issued guidance for mental health, convenience stores, and taxi services. And employers should consider doing training for workplace violence through consultants and police departments. That's an area where police departments have become much more active. Your local police department may very well be willing to come to your workplace and provide training about those situations to employees. There's several other rules that OSHA has issued recently. For those of you who have cranes and you did training before December 9, 2018, you don't have to conduct training again, but you want to be sure that you've got your documentation in about that training, and the evaluation and documentation requirements became effective in February 7, 2019, so if you haven't gotten those ready, you certainly should right away. Silica dust is another area. Respirable crystalline silica is created for cutting, sewing, grinding, drilling, and crushing stone. OSHA's issued 2 standards in this area, one for construction, the other for general industry and maritime. About 2.3 million employees are affected here. Another area that OSHA talks about a lot is beryllium. And this is of importance because of the possibility that beryllium that's in your workplace could contribute to lung cancer. OSHA recently has begun enforcing the general industry standards here. Earlier this month, it began enforcing the general industry requirements for change rooms and showers. And a year from now, it'll enforce the general industry requirements for engineering controls. Forklifts is another area where OSHA has stated as recently as this month that it wants to update its rule for forklifts. In fiscal year 2017, OSHA issued citations for over 2,000 violations and penalties in excess of $5 million. I can tell you that this is an area where, unfortunately, we have several employers who've experienced fatalities. While the industry developed consensus standard has been updated most recently in 2018, OSHA's rule hasn't changed. You should expect changes there. So with that, we'll take any questions that you have, and I know there have been some questions. We'll proceed to go through them, and we'll stay later if there's questions. And
so the first question is, under OSHA's general duty clause, how does an active shooter training situation fit in? Should employers offer active shooter training? Is it a recognized hazard likely to cause death? What training should be comprised of or include standards? How do different jurisdictions handle this? Other thoughts or issues? So this is there are a lot of questions around workplace violence. And as Fred said, you can bring in a consultant or even the local police department to provide free training at the facility. Whether it's a recognized hazard depends on the workplace. I can tell you, in certain circumstances, OSHA has identified workplace violence as a potential recognized hazard. Healthcare, retail, taxi drivers. And so in those industries, we would certainly recommend you provide some form of workplace violence training. Active shooter is part of that training. It's not the entire thing. California OSHA has issued workplace violence regulations related to healthcare. There is increasing threat, and you move to issue some type of similar regulations in related to hotel workers, particularly housekeepers. So this is certainly an area that we could talk for hours on, because it is one of these situations where there's a lot of movement going on in recent years, and but there's no set standard as to what is required or not. The next question is the loss of a fingertip considered to be an amputation? The answer is yes, it is. Now, if it's just skin, you have an argument that maybe it is not, but generally speaking, OSHA will consider a stiff fingertip to be an amputation. The next question is, what are common ways employers violate respiratory protection standards, hazard communication standards? Training on both of those are key parts there. For respiratory protection, lack of training regarding the use of respirators, lack of medical documentation and certification on the use of respirators. So if you're using a specific type of respirator, employers are required to perform medical tests and also fit testing to ensure that the respirator is safe and appropriate. Sometimes if you use a nuisance respirator, which is just a paper respirator, you're required to provide, it's called I forget the name of the appendix, but it's a form where the employee is required to sign off on it. Hazard communication, again, training on it. Failure to maintain proper all safety data sheets at the work site. Failure to have an updated HAZCOM program pursuant to recent regulatory changes. Those are the key areas there. Moving forward.
On the question of if an employee is traveling on company business and suffers a heart attack in the airport, should that be reported to OSHA? That would not be a situation that you need to report to OSHA, and it probably doesn't need to be reported to workers' comp as well. One area that you can often get some good protection here is contacting your workers' comp insurer, letting them know about a situation like this, and asking if that is something that needs to be reported either to workers' comp or OSHA. They often can be of help to you, and of course, we'd be happy to help you, particularly on the OSHA question. Another question here has to do with, we are not a high-risk injury establishment. We are a service organization with employees working in an office setting. Should I still consider submitting the OSHA 300A and 301 forms? Well, the OSHA 300 and 301 forms, you are going to need to prepare, but you just basically keep them in your workplace. As to the OSHA 300A form, the OSHA website will provide you with, it's rather detailed information about which employers need to provide the OSHA 300A form. I would say it's a general proposition, a service organization is typically not going to need to provide that form, but I think you should consult the OSHA website or consult us if you have questions in that area.
What trainings are required for IT services industries? So this is a bit difficult to discuss in the abstract, but in order to determine what trainings and what programs you need in any workplace, it's important to do a hazard assessment to identify what are the potential hazards in our workplace. And then from there, you can determine, do we have, for instance, in IT services, you may have hazard communication, because even though you're not using normally caustic chemicals, OSHA has taken the position that bleach, cleaning supplies do require hazard communication in SDSs. You could have electrical issues. IT services, there's with routers, a lot of wiring, could be electrical issues there. I'm trying to think of anything you can think of, Fred, that may apply there.
No, I have a similar reaction.
Yeah.
I think that was a good answer. Another question has to do with whether a blood clot develops on the airplane while on travel for work purposes. Is that a reportable incident? I would say that is not a reportable incident. If Carrie has any different reaction, then let me know.
So this is a tricky area of law, because is it traveling on work? It's been found by OSHA to be in certain circumstances to be work related. But is the blood clot, is it work related truly, or was it aggravated because of work, which creates its own unique issues? This is a very academic type of question here. I think you could go both ways on it, to be honest with you, Fred. I think you could say, I think OSHA may take the position that it should be reportable, but I think you would have employers have a good argument to say that it's not reportable.
But in that situation, certainly one area is it very likely is going to be reportable for workers' compensation purposes. And if OSHA is going to take the position that it's reportable, then that would be an area where I'd rather be safe than sorry.
All right, so then there's a follow-up that said, doctors said it developed due to long flight to South America from U.S. So here's an interesting part. OSHA's jurisdiction is only within OSHA's, or the United States territory. If we're outside of the territory by the time the incident or the injury occurred, it would technically not be reportable.
And the answer there, I completely agree with Carrie on the OSHA answer, but if that's a workers' compensation question, you should definitely check with your workers' compensation carrier, because in more situations than not, that might be reportable as a workers' comp related injury.
And so just another example, say someone is traveling on business overseas and the plane unfortunately were to go down, if they are outside of the U.S. territory when that accident occurs, that would not be a reportable incident, or reportable either.
And then we have a question under the OSHA general duty. Oh, I'm sorry.
Same.
The same question? Okay, great. All right, we're good? All right. And if any of you have any further questions, feel free to call us. We appreciate everyone being present today, and we'll be happy to assist you with any further questions or incidents that may arise.
Thank you, everybody.